In New York, Joanna Greenwald is going to spend some time with us, former prosecutor, currently a criminal defense civil attorney in New York and New Jersey. We're glad to have Joanna here with us.
Thank you.
Let's start off, Gene, with you if we can. Let's go back to... Let me bring Joanna into our conversation here. You know what? Jury deliberations are fascinating things.
They truly are.
They really, and when you, I think it's so helpful when you get to talk with jurors afterwards and you learn what was going on in that room and how sometimes it's so different from what you as the lawyer, either prosecutor or defense attorney, think they should be focusing on. When you hear Gene say here in this case that the juror foreperson said, well, you know what, we were sort of robbery, theft. Does that surprise you at all, given the nuances between the two?
This is the type of thing, as a criminal defense attorney, that drives me nuts.
Why do you say that?
This personally would drive me crazy if this was my case. And I have a case very similar to this right now. This is what bothers me, is that theft is a mens rea situation, meaning that it's your criminal intent, criminal intent. Somehow they found that he had the intent for second-degree murder, but didn't have intent for theft, for robbery, but of, if you will, for them, the criminal possession for New York, we would say, of stolen property, of doing that. How all of a sudden they could differentiate. Where'd that go? Where'd that go?
Do you think it might have been that, and I'm not trying to denigrate their work at all, that they had said, look, we've said guilty to second-degree murder. You know, we know, most jurors know that that's a pretty, that's a pretty serious charge. Yeah, and we'll say robbery, theft, we'll say theft, we've got them on the second-degree murder. Might that be?
Well, you know what? I think that it's almost like it's to assuage a certain situation, because I know you asked the question about the hate crime issue part, the undertone, if you will, or the overtone, depending on who's watching. And I think they were sending a message. Jurors are, it's a toss of a coin. I could be watching body language all day long, but they could be doing the whole different thing in the room. And it could be a message that this can't be. Okay, as much as you don't want it to be entering it into the courtroom, that they were sending a message, because as we were listening to Gene, what evidence did they have? Everything at best was circumstantial. At best you had a robbery or a theft that occurred, or a criminal possession of a criminal possession of stolen property at best.
That's where they get
but you don't have that he did something. And she
even said circumstantial.
And it was circumstantial. But it's there.
Hold your thought, because I want to get back to that in a minute. But I do want to take our viewers again back inside of the courtroom late on Friday after.
Got a call on his life, Judge, and he knows that, and he's run from that through the horror of the things that he's went through in his life. But Joey, I do not believe would ever hurt anybody in this way. I do not believe he's guilty of these charges. We ask you to have mercy upon him in your sentencing.
So then those are some of the emotional statements by the defendant's adoptive mother and his pastor before the judge imposed sentence on it. Talk a little bit with Joanna Greenwald, who's our guest here. You and I were talking as we watched this about the fact that when you have such a brutal slaying such as this, there are all sorts of levels of victims inside of this courtroom, aren't there?
Multi-fallout. It's not just that you see two sets of parents speaking. Not one lost a son, now two. And now you have, they say, adoptive mother. That's his mother. When you adopt a child, you are their mother. So that family has lost a son that day as well.
It's interesting because she, you know, you look at her, and as opposed to his biological mother, who we're told was doing drugs when she was pregnant with him, would explain a lot of things, and came back into his life after abandoning him and introduced him to drug use. And you look at the adoptive mother there, and you certainly have to say she seemed like she had done all the right things in her life to try to do something with him, and then all of a sudden she finds herself inside of a courtroom watching the adoptive son be sentenced to life in prison. And it brings me to that question about him, about the defendant here. We know that in the opening statement, the defense said to these jurors, you're going to hear from him. He'll tell you, he'll admit to certain things, but he'll tell you he wasn't part of the killing here. And then the decision was made, and we know that ultimately it's made by the defendant, but then a decision was made not to put him on the stand. My question to you is let's go to the back end of this first, and that is this the kind of case where it might have helped to put him on the stand and to say to these jurors, look, there's some bad things that I do and some bad things I did here, but I want you to know I wasn't part of this murder. I didn't know they were going to do it. I never would have done something like that. What do you think?
I think it's a real tactical question, but based on what he had to say and what we saw him say, it potentially would have been a good idea because it would have humanized him. Because remember, there's a message being sent with a hate crime, so at least humanized him. But going backwards to your question, as far as rule number one, don't ever make a promise to a jury you can't keep. ever. And don't say someone's taking the stand, even though it's not a defense attorney's burden to put them on the stand. Don't make a promise and then don't do it. They don't forget that.
No, everybody forget. And then I got to ask you this, because everybody has talked about this, and the tattoos that he shows up with. And we talked to his defense attorneys about this, and you know, we can't control everything a client does. No. And they had said to us, every time he showed up with another tattoo, they were cringing and they were begging him to please stop doing this. They did an interesting thing, I thought, and it's something that I mentioned at the very beginning of the trial. I said, if I'm this defense attorney, at the end of the case, I'm going to ask the judge to give an instruction to these jurors. Say, look, whatever you might think about tattoos, you can't hold it against the defendant. It can't enter into your thought process at all. I thought it was a good thing to do. Do you think so?
That's a highly unusual jury instruction check. What I would have done potentially a little differently is that I would have given him some religion, as my husband has a different way of saying it from the South. They say it a little differently. Actually from Tennessee, and they say it that basically you are dressing up, you are covering up. Get great makeup artists if I can, because just as you don't want someone judging someone's sexuality and their background, you also don't want them judging. People judge on tattoos all day long.
Oh, sure.
Looks count.
Yeah, I actually saw the first murder trial I was trying as a prosecutor. The defendant actually was tattooed. He ended up being convicted. It was a particularly brutal murder. And I remember seeing a study, and I don't remember the numbers, I don't know if it's still valid or not, because this was a long time ago, it was 1976, 1977, I think, about some enormously high percentage of convicted murderers are tattooed.
Yes,
and
that's true.
You know what, I would just be terribly afraid that some juror in the back of their mind is looking at him saying, well, does he look like he's somebody who could take somebody else's life?
But it's also stripes. It's almost like, you know, when you, just like a notch on a, you know, something else. It's also, people have a preconceived notion about that. And what does that mean?
Point. Yeah, very good point. And it's sending messages, and so much about what happens in a courtroom is about sending messages. In the meantime, we're going to step aside for a quick moment, come right here. Joanna, let me ask you to sort of get into the mix of this conversation here. It's a fascinating issue for a couple of reasons. One has to do with the individual involved here, the prisoner from Alaska, and we can talk about that in some detail, but it's essentially, to give you some background here for it, this is a man who's found guilty of rape, serves about 14 years on the sentence, the conviction, and has said that, well, I want to get access to DNA testing. I will pay for it myself. And even after the fact is that he had turned it down before his trial, and that he, at his parole hearing, confessed to being part of this, and then got released on parole, he has still said, I want this to take place. And he said, one of two things are going to happen. If I get this test, you will either absolutely definitively prove that I'm guilty, or absolutely definitively prove that I'm not guilty. It's an interesting position that he's taken, and his position really extends out to the entire criminal justice world, does it not?
It does. It's the bigger picture. And I say, as a criminal defense attorney, I say, hooray if this goes through.
Right.
Because as we were talking, it works as a sword and a shield. One, I could use that. My sword is that the DNA could either will relieve my client as far as not being there and not having anything done it, and use it, but the shield for the prosecution is that they could nail me and that's it, and I'm dead as dead, and they got me no matter what I say.
Yeah, you're right, because it ends the case one way or another. But for this defendant, people might be saying, well, if in fact he already was paroled, and if, in fact, he confessed to the parole board to get himself out, as you know, to get out on parole, essentially you have to accept responsibility. Or nobody's going to let you out early. He was released, but he's back in jail now because he's been convicted of some other crimes, going to have to do that time, and then going to have to do the balance of the time on the rape charge. So, if, in fact, they give him the ability, he does this test, and he says, okay, innocent, will that then prevent him from having to serve that additional time? Is that why he's doing this after all this time?
I think yes, number one. And two, depending on the state, they have second felony offender status when you have enhancement.
Right.
and his prison sentence might be enhanced because he might be a second felony offender.
Yeah.
And if you knock out one, now you have not 2 strikes but 1.
Yeah.
And he could do that, and then potentially he sets the groundwork for every other state to be following suit.
Yeah.
So
there are a lot of reasons for him, even though his case has played out the way it's had. We're going to bring in our in-session senior editor, Fred Graham, now to join us, and Fred has jury returned that verdict. Joining us live now outside the courthouse, our own Gene Casares, who's done such a marvelous job covering this for us. Here in our studios today, Joanna Greenwald spending some time with us. Always like to have Joanna here with us. So let's bounce back out if we can. And Gene, let's start with you, if I might. What sort of reaction was there inside of the courtroom? It appeared to first thing tomorrow morning as we pick this up. Beth Karras, live again. Thanks, Beth. We'll look forward to talking with you. And I want to also thank our good friend Joanna Greenwald for spending some time with us here today. We had a lot to talk with you about, Joanna. It's always good to have you with us here.
Thank you so much.
Does it for us for today. Reminder, we'll be back here tomorrow at 1 o'clock.